Healthcare repeal challenges continue to pile up in the courts. The New York Times is reporting today that many Congress members are now baffled, yes, baffled by the new healthcare law. Joining us now to make sense of it all is Democratic strategist Carl Jeffers. Carl, when I cancel my health insurance and then sue the federal government for refuse to pay the taxes for not having health insurance, you're telling me I got no chance in the court system?
Well, if you do it that way, you probably have very little chance. But what I think is happening is that so many states, we have at least 15 states now that have filed suit to challenge the legality of the health care bill, and they will follow that through to the Supreme Court. I question the ultimate success of that because theoretically the Supreme Court would actually have to use an activist judicial philosophy in order to overturn health care, which is ironic because conservatives, particularly with the upcoming nomination, suggest that what we don't need anymore of are activist judges. But when you think of the Supremacy Clause and when you think of the Commerce Clause, which provides the broadest possible taxation powers, and the Supremacy Clause, which supersedes the states, the reality is that only an activist judge, in the face of that precedent, Social Security, taxes all mandated and all established, would overturn that in order to get a result that they favor. What conservatives may have a better chance of doing is what some legislatures are doing, which is enacting laws within the states to challenge and, in fact, de facto nullify health care in that state, because at least it's now a standing law, and then supporters of health care would now have to go to the courts to challenge the right of that state, and the law would stand until they get a stay.
But Carl, is that your way of just saying that, hey, a judge shouldn't do this, and all of a sudden they're an activist judge if they make a ruling? That's their job, to determine if this law follows the Constitution, is legal or not. They're not being an activist, they're just making a ruling.
Well, I don't know if that's just my way of saying it, because I usually have a way of saying what I understand, pretty directly. So what I would say this, though. My point is, the argument you just gave me is exactly the argument that we come up with to counter those who say we have too many activist judges. You need to interpret the law as it stands at that point and as it affects the people that are involved in those jurisdictions.
Wait, Art, did you just turn my question back on me?
I may have, but
you're good.
Well, it's happy hour.
Carl, let me ask you, a Rasmussen poll just came out showing that 58% of Americans support repealing this law.
Yes.
What you're saying is don't waste your time. It's not going to happen.
I think that that's an excellent point, Sandra, because I do think that if you are opposed to the health care bill and you are conservative and Republican, the most effective option would be, in fact, to run candidates and to vote in November for congressmen and congresswomen who will, in effect, vow that when they take office, they will oppose the bill and try to repeal it. But remember, even that will have limited success until 2012. Because the president will still be president, and even if Republicans gain control of the House and the Senate, he would still be able to veto the bill, which he would assuredly do. And I can tell you that even as I predict, Republicans will make tremendous gains this November in both houses, 5 to 7 seats in the Senate, 25 to 35 seats in the House. I do not see them taking control, and I certainly do not see them getting a veto-proof majority that could overrule the president's veto. So you got to get the House and Senate first this November. Then 2 years from now, you'd have to put Mitt Romney up there with Sarah Palin or Tim Pawlenty. Those are your best candidates. And then you could get maybe the White House back. Then you can repeal health care. And bottom line, by then, there will be millions of Americans who are opposed to it today who will feel far more comfortable by then, because many of the provisions that do benefit many working class and middle class Americans will have kicked in.
Carl, you avoided my original question talking about an individual suing the states.
Yes.
You talked about states not having a chance in the courts. What about me as an individual? I am being hurt by the government fining me 2% of my income for refusing to pay a health insurance company money. I'm going to take that to the Supreme Court. You can't tell me I don't have a chance, and I do not need an activist judge to rule in my favor on that.
Well, you know, Cody, I also know that you're a libertarian.
I am not a libertarian. I'm a free-thinking individual American.
Well, we don't even have a category for that.
That's called American.
But the reality is that probably offers, although philosophically and intellectually, more of a supportable position. It probably offers even less of an opportunity to win, because those individual challenges in many cases have actually been discarded and dismissed even before they get to the federal courts for rulings. So
I tell the federal government, bring it on every time. Bring it on. I'm suing.
Why that House insurance or get charged.
No, you know what? I'm canceling it, and I'm suing the federal government.
Okay.
Bring it, guys.
Carl Jeffers, thank you very
Carl.
much for joining
My
us
pleasure.
on Happy Hour
Good to
today.
join you
Good to
today.
see you. All right.